Good afternoon, everyone. My name's Ben Ralston. I'm a professor here at the College of Law and a member of the Guest Speakers Committee for this academic year. A warm welcome to everyone who's joined us for today's lecture, whether you're here in the room with us or watching on the live stream. We're glad you took time out of your day to join us. As we begin today's event, I acknowledge we're gathered on Treaty 6 territory and in the ancestral homeland of the Métis people. In honoring this land's rich history, we pay our utmost respect to the First Nations and Métis ancestors who have shaped this place, and in doing so, reaffirm our profound connection with one another. Today, we have the pleasure of welcoming the 2025 Silas E. Halyk, KC, Visiting Scholar in Advocacy, Boies Parker, KC, to deliver today's lecture. The Visiting Scholar position, also known as the Halyk Chair, was created in the fall of 2009, thanks to a generous gift from Silas Halyk, along with additional gifts from Si's friends and supporters. These gifts support an annual visit from a distinguished legal advocate who delivers this lecture and spends time with our students who are involved in various advocacy programs. Over the years, gathering for this lecture provided us with the opportunity to note and honor Si Halyk's exceptional legal career. As many of you know, the legal community in Saskatchewan and beyond was saddened by Si's passing in December. As was noted in his obituary, Si's passion for advocacy and his unwavering belief in the rule of law propelled him through 6 decades of legal practice. His journey encompassed roles as prosecutor, criminal defense counsel, civil litigator, negotiator, Indian residential school settlement agreement adjudicator, and esteemed lecturer. Si was born and raised in Saskatchewan, and he earned his LLB from this college back in 1961. He was a leading lecturer in the Federation of Law Society's criminal law conferences in the 1980s and the 1990s, represented many prominent clients, and served as counsel in several public inquiries throughout the country. He was especially honored to be chosen by the Federation of Saskatchewan Indigenous Nations as their counsel on several occasions, including representing them at the Neil Stonechild inquiry in 2003. The Silas E. Halyk KC, Visiting Scholar in Advocacy, was created because Si had a desire to help USask Law students learn how to become good courtroom advocates. As such, the position is bestowed upon a prominent legal advocate. Now, before I introduce this year's chairholder, Ms. Boies Parker, I'll invite former Provincial Court Judge, the Honourable Jerry Morin, to say a few words about his friend, Si Halyk.
Thank you very much. Good morning or good afternoon, everybody. Certainly, Si, as we know his history here, when you think back, anybody that's practiced law from 1961 to the time that he did finally quit, I think you think the Bill of Rights were just being introduced. You think of Calder decision in 71, 72 in relation to Indigenous rights, and you look at the Charter of Rights. All those things that evolved as he was practicing law. I remember our discussion one time on Stinchcombe. He says, I practiced how many years before Stinchcombe? We couldn't even see our clients, never mind get disclosure. And to be an advocate in those times, one has to think you had to have the perseverance and the mental aptitude to say, I'm here for my client. Doesn't matter what I'm up against. I've had the opportunity over the years in being friends. When I started practicing back in 1987, 88, I phoned him up if he would be my mentor because I was practicing in PA, and PA was a feisty place for any lawyer. You didn't want to get a mentor from there because they'd be fighting you next week. So I figured I'll go to Saskatoon. So I got Si Halyk and a few other people. I remember Ted Pryle was one of them, late Ted Pryle. I felt I needed somebody, and Si was always in my corner. He was in my corner when we did a murder trial together, first-degree murder of 2 people that were charged. We were on the defense side together. Do you think I've learned lots? I have from Si in terms of how to deal with cross-examination, how to deal with police witnesses, those type of things. So I remember him well. And we think in terms of, I said, you became a lawyer when my people finally got to vote. So he has quite a history. And I certainly think that many of us, you can't help but think, when you are an advocate, who you're there for. Cy never forgot who he was there for. When we worked on a major file together dealing with casino advocacy or casino, I suppose, working with the government, trying to work out a deal on what casino rates would be. Those were pretty major heady times with Cy, and being with him when we're negotiating. Again, you sit back, you watch, you learn, and those are the skills that I was lucky enough to be involved in. When we were sitting on the same hearing with the Nerland Inquiry back in the early 90s, dealing with Nazi stuff, and he was there, and he was representing the Queen's Bench, I was representing the family. I learned lots through that in our discussions. I think those are things I remember so acutely with Cy. He was a lawyer's lawyer. He was a judge's lawyer too when he represented the provincial court in commission hearings. He was a man to be honored and a friend, and I'll always remember that. Thank you.
Thank you, Jerry. We're grateful to you for sharing those memories with us. I now have the honor of introducing today's speaker. Catherine Boies Parker, KC, is a part of the team at Arvay Finlay, LLP in British Columbia. She's called to the bars of British Columbia, Ontario, and Yukon. Her areas of practice include constitutional, aboriginal, administrative, privacy, and environmental law, as well as labor and employment law. Catherine has appeared at all levels of court and before numerous administrative and regulatory tribunals. She provides litigation and policy support for a wide range of public bodies and conducts workplace investigations for both private and public clients. Catherine is a frequent guest lecturer on topics such as constitutional law, privacy law, and civil liberties. She's the founding president of the Pacific Center for Environmental Law and Litigation, a former director of the Mary Manning Center, Child Abuse Prevention and Counseling Society of Greater Victoria, and a former chair of the Orca Children's Advocacy Center Society. Catherine was awarded the 2008 contribution to the Law Awards from the Victoria Bar Association in recognition of her work on a case involving the charter rights of Victoria's homeless. In 2009, she received a Human Rights Award sponsored by the Vancouver Island Human Rights Institute and presented by the Honourable Stephen L. Point. In 2016, Catherine received the George S. Goyer QC Memorial Award for Distinguished Service, and in 2017, she was honoured with the designation of King's Counsel. Please join me in welcoming Catherine Boies Parker.
Good afternoon, everyone. Thank you for coming. I got something from my grandson, so my voice is a little off today, and I won't be shaking anyone's hand, but hopefully I can make it through. Thank you very much for that introduction, and thank you so much for having me here. I'm very pleased and very honored to be here. I didn't ever have the pleasure of meeting Cy Halyk, but I have heard an awful lot about him. He seems to have had all the qualities that you want in a litigator: talent, energy, courage, conviction, and creativity. And he seems to have a wonderful gift, seems to have had a wonderful gift for mentorship. So many of the prominent lawyers that I know from Saskatchewan seem to have been touched by him. So I want to express my gratitude for the opportunity to be here, my condolences to his spouse and law partner, Catherine Knox, and the rest of his family for their loss. I hope you're comforted by the fact that he will be well remembered, his name always known by the people he touched, because he seems to have made a huge difference in the lives not only of his clients, but his colleagues and generations of lawyers who came after him. So it's a real privilege to be here today. I'm going to talk about civil litigation because that's what I know, civil litigation involving constitutional rights. And in that kind of litigation, as in all kinds of advocacy, you can't overestimate the importance of mentorship like Cy was able to give. There's nothing to compare to the benefits of being able to learn from someone as you go. And I stole part of the talk today, the title of my talk today, from someone who was my mentor, my treasured mentor, Joe Arvay. Joe was a fearless litigator. He appeared at the Supreme Court of Canada about 75 times or so in some of the most important constitutional and civil rights cases of the last 30 years. And he was often asked for advice to give new lawyers, and he would often tell them simply, do good work. Use your skills to make the world a better, kinder, more compassionate place. Fight for social and environmental justice. Fight to protect the rights and dignity of those most vulnerable members of society. Do good things. But I really like that phrase, do good work, because of the double meaning. Because do good work also means do your job well. And that's what I want to talk about today. The challenges involved and the importance of doing really excellent work when you're engaged in public interest advocacy or other litigation that protects the rights of vulnerable groups. In many cases, that kind of litigation is successful and effective not just because of the groundbreaking legal arguments that get a lot of the attention, but because of the hard work and excellence in the basic legal skills that you're learning here. It's the hard work in developing the record in those cases and mining the existing law for precedents and legal frameworks that help the court develop the law that are a precondition for success for those interesting legal arguments that lead to an evolution in the law. You know, I prepared this talk for law students, and I see an awful lot of accomplished lawyers here, so I'm just going to tell you guys this stuff too, okay? In any piece of litigation, you're going to have two jobs, two tasks. First, you got to get the judge to want to find for you, and then you have to show the court a legal path that allows them to do that. In many cases, that first one, getting the judge to want to find for you, involves building an evidentiary record that allows the court to understand the facts from your client's perspective. That's true in any litigation, but there are special challenges when it comes to the rights of particularly vulnerable plaintiffs. In this kind of litigation, as in any litigation, you have to listen carefully to your clients, and then you have to translate their needs, their concerns, their experiences into a framework that the court can understand. And that concept of translation, I think, is fundamental to one of the obligations that rests upon each of us as lawyers. In law school, you're learning the language of the courts. You're learning how to frame facts and structure legal arguments in a way that judges will respond to. And knowing that language is a huge privilege because it gives you access to the arena where rights are vindicated and where law is developed and changed. Because you know that language, you can listen to your client's experiences and then you can translate them into a framework that the court can address. In doing that first step of building your record, you have to be both, I would say, rigorous and creative. You need to know the rules of evidence so that you can follow them as closely as you can when you're telling your client's story, because courts will be much happier advancing the law if the evidentiary record is solid and framed in familiar ways. But to really serve your clients, you may have to push the court out of its comfort zone, and that may involve bending or stretching those evidentiary rules. But to do that effectively, you have to know the rules really well. And the same is true of the second part of your job, giving the court a legal path to find in favor of your client. If you're lucky, and it's an easy case, you just have to show how your facts fit into the established legal test. But perhaps because of all the time I spent with Joe Arvay, I never thought it was a real overwhelming obstacle if the law hadn't quite developed the right legal test to recognize the rights we were trying to vindicate. So I've been very lucky to act in cases where we could persuade the court to extend the law or advance the law to address our clients' interests. But my experience tells me that courts are comfortable doing that in growing the law only when they're comfortable that what you're asking them to do is, first of all, within the scope of their expertise. Secondly, consistent with sort of their role in the constitutional order, that you're not asking them to do the job of the government or the legislature. And three, when you can convince them that what they're doing is really just the logical extension of everything that's come before, kind of inevitable. And you can only persuade the court of that if you really understand deeply the law as it currently exists. Joe was great at changing the law, but that's because he knew the existing law so well. So if you want to make the law change, you gotta understand it to begin with. And I'd say this is the other part of the responsibility that lies on lawyers because of this privilege of understanding the law. The law is changing all the time. And in law school, you're learning the tools that make it change. And so I say it's your responsibility, it's the responsibility of every lawyer to be sure the law develops in a way that protects the people in our society who may not have had access to the courts and the law as it has developed for many, many years. So I want to explore these concepts in the context of three different kinds of litigation that I've been involved in. The first is litigation where I've acted for homeless people in vindicating their Section 7 rights. The second is litigation involving rights protected by Section 35 of the Constitution held by Indigenous people. And the third is cases involving climate change. With respect to the first, I have acted for homeless people in Victoria a few times, including the Adams case, which was the first case in Canada to recognize that laws which prevent homeless people from creating shelter for themselves and sheltering together are a breach of Section 7 of the Charter in circumstances where there is not adequate shelter available to them elsewhere. Section 7, of course, is protection for life, liberty, and security of the person and the right not to be deprived thereof except in accordance with the principles of fundamental justice. I also acted in a number of cases involving injunctions against homeless people, including the Adamson case. And in that case, at first instance, the court found the balance of convenience favored leaving up a tent city that was outside the Victoria courthouse because of the benefits to the homeless people and the lack of shelter. And later on, a few months later, there was more shelter made available, and then the injunction was granted. But the reason I want to talk about those cases is because of what I learned about building the record in those kinds of cases. The objective there was to make the court understand something that was wholly outside of its experience and was not the subject of any law in Canada at the time, which was sort of the difficulty of the day-to-day existence of homeless people, the role of what seemed like fairly innocuous bylaws in exacerbating the harm to those vulnerable people, and the benefits of sheltering together that meant that taking that away from them rose to the level of a Section 7 violation. So we used all kinds of evidence to make that case. We used expert evidence from medical doctors and sociology professors, and we used studies and reports from the city, the province, the federal government, international bodies. We had evidence from service providers, from homeless shelters and addictions counselors, from police officers, from the pastor of the nearby church, from supportive neighbors. And all of this evidence was critical to give the court an understanding of what was really at stake in the case. But the evidence of the homeless people themselves was especially important for the simple purpose of giving a face to all the statistics. Because it's one thing to read a report that says homeless people are 7 or 10 times likely to be the victim of violence. It's another thing to read affidavit after affidavit or hear testimony after testimony for individuals who have actually suffered repeated attacks on their person and their possessions. It's one thing to have a service provider explained that sleep deprivation causes harm to homeless people. And it's another thing to have individual after individual explain what that sleep deprivation does to them, how it impacts their physical health, how it may exacerbate the psychosis they suffer from, how it interferes with their ability to carry out very basic tasks that the rest of us take for granted. It's one thing to have a sociology professor explain the cause of homelessness, and it's another to hear story after story of the individual abuse and neglect that led people to where they were that day. So many of the plaintiffs and the witnesses in those cases consisted of homeless people facing a broad variety of challenges. Almost all of them had a history of abuse involving some form of authority, and inevitably they had a history of negative interactions with the justice system. So taking evidence from those people can be very tricky, especially when you're under sort of the time frame of a threatened injunction, which you often are in those cases. It can take a long time to get that kind of evidence. You need an introduction from someone that that person trusts. You have to spend enough time with that person so that they can, at least to some extent, trust you. You know you won't get the whole story on the first try. You have to come back and demonstrate you're committed to listening. So you're going to have to be creative about how you're going to muster the resources to take this kind of evidence, because you're probably not getting paid. In one case, we asked some professors at UVic if there were any law students that would help us do this. And for the next few days, we had a tent city full of law students sitting with individual homeless people for many, many hours, taking down their evidence. And in that sort of one-on-one environment, the stories eventually came out. It wasn't always obvious when we were taking the evidence how it was going to be useful, but eventually patterns emerged. And we could use that evidence to demonstrate that these rights that were being interfered with were fundamental rights protected by the Constitution. So you have to take that evidence, and then you have to help the court utilize it. That means developing written arguments, and here I'm going to get really picky, that provide pinpoint sites to all of the evidence you've given the court. You can't just put a truckload of evidence before the court and say, figure it out. You have to take the time to organize it, and you have to tell the courts exactly what to do with it. I remember one late night before an injunction application saying to somebody writing the argument, you got to cite all those affidavits, put the paragraph number, and they say, he's never going to read all those affidavits, just not going to read them all. He read them all. He cited them all in his decision, right? And he was clearly moved by that evidence. But you can't just put a binder and say, go for it. You got to tell him where it is. It's hard work. When you're trying to educate the court about a world that is foreign to them, you have to bring enough evidence that you immerse the court in it. And at the same time, you have to have enough attention to detail that the court trusts that evidentiary foundation you're asking them to proceed on. And when the court is convinced the evidence is solid and that the evidence points towards a particular result, the court will be much more comfortable extending the law in sort of new and interesting ways. Educating the court is particularly important with respect to the next category of cases I want to talk about, those involving the rights of Indigenous people protected by Section 35 of the Constitution. One of the cases I was recently involved with was the Restool case in Ontario, which involves the interpretation of the Robinson-Huron, Robinson-Superior treaties. At issue was the provision of the treaty that says that the land subject to the treaty, if it proved productive, the annuity would be increased. The annuity at the time the treaty was signed in 1850 was something like less than $2 a person. It was increased once in the 1870s to $4 a person, and the Crown took the position that that exhausted their obligation to increase the annuity, and that it was just a matter of unfettered Crown discretion whether they would do any more than that. So, as you probably all know, the courts have said for some time that Section 35 rights have to be understood in a manner that's respectful of both the Indigenous perspective and the common law perspective. But it can be really, really challenging for a common law court to understand that Indigenous perspective. And Restoule, we argued that the Anishinaabe treaty signatories would have approached the treaty through their understanding of Anishinaabe law, their understanding of Anishinaabe diplomacy. And the court agreed. The court said that the Anishinaabe would have expected the Crown to share the wealth in a manner consistent with Anishinaabe principles of respect, responsibility, reciprocity, and renewal, and that limiting the increase to $4 when the wealth of the territory was enormous would have been inconsistent with that understanding, with that part of Anishinaabe law. And eventually the Supreme Court of Canada agreed and found that the Crown had acted dishonorably in a manner that made a mockery of the treaty promise. And just for your information, in that case there were two groups, the Robinson-Huron Anishinaabe and the Robinson Superior. The Robinson-Huron settled that case for past compensation some time ago. The Robinson Superior have not yet settled, and the Supreme Court of Canada gave them 6 months for the Crown to make an offer for how they would meet their obligations under the treaty, and that 6 months is up today. So you maybe we'll be reading something in the paper about what's going to happen there. What I learned from Restoule is that we need to be ambitious about educating the court on the Indigenous perspective. Don't be scared of doing this. Don't be scared of taking chances. Courts know they have to do this. In 2012, Chief Justice Finch of the BC courts wrote a paper called The Duty to Learn about the obligation of common law courts to learn about Indigenous legal orders. And a decade later, Chief Justice Bowman wrote a paper called The Duty to Learn, urging judges to give priority to the Indigenous perspective. This is what Chief Justice Bowman said to legal decision makers. Listen to the real stories of those Indigenous persons who stand before the court who live by Indigenous law. Listen to Indigenous writers and researchers who have expert knowledge and lived experience of Indigenous culture. Listen to the counter stories. Listen, question, recognize the truth, and act. That's a pretty powerful statement to the courts. And I recommend it to you as well. That's what you need to do. Professor Kent McNeil wrote a book called Flawed Precedent, which I also commend to everyone here. In that case, he talks about how the St. Catharines Milling case was decided without the court having any actual evidence before it of the Indigenous people whose lives the court felt free to opine on. Instead of evidence, the findings of the court were based on the biases and prejudices of the court, products of the specific background of the judge. And those findings led to a conception of title that had no regard for the Indigenous perspective, but instead was actually firmly grounded in racist assumptions. We're still dealing with the impact of those assumptions, the way the law is framed. But evidence from and about Indigenous communities is, I think, the antidote to the tendency of the common law to unconsciously incorporate and reinforce those biases and stereotypes into our conceptions of legal rights. So, in cases involving Section 35 rights, it's critical that lawyers provide courts with the tools that they need to understand the Indigenous perspective. And again, what you have to do is sort of immerse the court in this evidence. And you have to be rigorous and creative in building that record. In Restoule, we had sort of traditional expert evidence, such as from a historian tracing the long history of Crown Anishinaabe relations prior to the treaty. What was new about that was not, the kind of expert we had, but the fact that he went so far back to demonstrate that this is how this relationship had grown for over 100 years. We had expert testimony about Anishinaabe law, Anishinaabe practices, political organization. But it also included some more unusual expert evidence. We had expert evidence about Anishinaabe law that consisted, for the most part, of Anishinaabe stories, stories that were later told in court to the judge. It included expert evidence on Anishinaabe use of metaphor and imagery and material culture, which was very important for the court to understand what had been said and recorded in the record by Anishinaabe participants throughout the time after the treaty was signed. Without understanding the way they spoke, the way they thought, it's very easy to misunderstand what was recorded in the historical record. It included elder evidence on matters such as Anishinaabe cosmology and language. And along with all that evidence, the court was further educated about Anishinaabe law through the incorporation of ceremony into the court process, including sweat ceremonies and feasts attended by the court and all counsel. We were lucky to have an open-minded and progressive judge. But there's a precedent there that everyone can draw on now. You can ask your court to pay more attention to your client's culture, to your client's ceremonies, to your client's worldview, in whatever way is going to be effective. So I said before, when you're acting for vulnerable groups like the homeless, you have to get the court to understand something that they have no experience with. But this is even more the case, in a sense, when it comes to understanding Indigenous legal systems, because you're asking the court to have regard to a whole worldview, a way of seeing things, and a legal order that may be sort of fundamentally inconsistent with their own understanding. So, for example, a key issue in Restool was sort of the degree of discretion that the Crown could exercise in determining how much to increase the annuity, something you're going to hear more about today from Ontario and the federal government, how they exercise their discretion today after 175 years. And from a common law lawyer's perspective, there may be sort of a hard line between a legal obligation and what you might do as a matter of, moral obligation by exercising your discretion. Under Anishinaabe law, there is no such hard line between those things. You are obligated to act as an honorable treaty partner as an incident of the treaty relationship. It's part of that relationship. It arises from that relationship, and it's going to have a lot of different manifestations. So it doesn't necessarily depend on any specific wording, and the obligations can't necessarily be defined ahead of time and exhaustively cataloged. Depends on what is required in the circumstances. That's a very different approach than a common law judge normally takes to legal obligations. But to get the judge to the point where they feel comfortable acting on that, where they feel comfortable administering a law that's supposed to be the product of intersocietal law, then you have to really immerse them in that world. And to the extent that your evidentiary record is consistent with the traditional rules of evidence, so much the better. The court will want a solid foundation on which to act, a foundation that can survive on appeal. But to be true to the Indigenous perspective, you may very well have to push the court out of their comfort zone in this regard. The judge might have to stretch a bit to fulfill the duty to learn. In Restool, we were very lucky because we had expert witnesses that had academic credentials, that had master's degrees and PhDs, who were also understood as experts that had understanding within the community. But the court's obligation to have regard to Indigenous legal orders doesn't depend on there being someone with a degree that can testify about it. So it's going to be your job to convince the court that they need to pay respectful attention to the voices and the knowledge that are recognized within the community. To the extent that you can provide the court with some sort of a analytical framework that they're sort of familiar with to assess that evidence, that's great. But you can't make it necessary for Indigenous laws to be more like common law for the court to pay attention to it. You can't distort the laws to make it easier for the judge to understand it. Again, you can't just throw all this at the court and tell them to figure it out. Especially when your evidence is going to take unusual forms, you have to help the court by ensuring that your legal argument makes clear what you want the court to do with each piece of evidence you rely on. You need to be really rigorous about citing that evidence and telling the court what you how you think it helps you. And you have to be really careful about giving the court a clear and specific basis to reject the evidence that hurts you, especially when the evidence comes from the Crown's perspective. And know that that evidence may still be based on racist and unacceptable assumptions, but your job is, through cross-examination and through your legal argument, to make that really clear to the court. You have to help them reject that evidence. Now, having said that about knowing exactly what you want the court to do with all your evidence, I'm going to say something contradictory. Sometimes there's merit in your legal argument. Now, you got to be careful about this. They get confused and they will get annoyed if there's too much color. And sometimes the importance of evidence doesn't become clear until you're at the very end of the trial. And this is especially true when it comes to Indigenous groups. Because unless you're a member of that group yourself, you may not, indeed you are effective while you're trying to educate the court about it. And so it may not be until the final argument that you understand why a certain piece of evidence was important to your client. So if your client thinks a piece of evidence is really important, you should probably try and get it in one way or another, because you may not understand that until the very end. Make sure that the evidence, for the most part, is obviously relevant and useful to the court, but you should be very respectful about what your clients think is important evidence. And now I want to talk about the third kind of case that I identified earlier, which is cases involving litigation. We represent a number of children and youth throughout Canada that are challenging Canada's actions regarding climate change as constituting a breach of their charter rights. The case was filed in 2019 in federal court. It initially claimed that Canada's conduct in permitting the release of GHG emissions at a level inconsistent with a safe climate system was a breach of Section 7 and Section 15 of the Charter, and also constituted a breach of the... There's a little bit that involved climate change, but I want to make this point at the outset. Climate science is complicated, but the evidence that we need to show, as it was 10 or 15 years ago, it's now well accepted that human-caused GHG emissions are driving climate change. It's well understood the rate of warming is much higher than the global average, especially the north. Forest fires and droughts and heat-related diseases and insect-borne illnesses and many other harms. If these have disproportionate impacts on Indigenous people, it's death in Canada. That's all been established. It has admitted it in various fora, and for the most part, it's been acknowledged by the Supreme Court of Canada already in the GHG reference. And there's abundant evidence that I don't think will be hard to get a court to accept, that because of their developing bodies and their developing brains and their overall vulnerability, children are at disproportionately high risk to the harms of climate change. So, unlike those other types of cases that we discussed, the challenge in climate change litigation is not really about getting the court to understand facts in a novel way. It's about framing the issues in a way that the court feels that it's competent and constitutionally capable of providing you with some sort of remedy. And it's about growing the law that's going to give them the authority to do that. So in LaRose, Canada brought a motion to strike the claim, which was successful at first instance. They said that the charter claim was non-justiciable and had no prospect of success because the range of conduct that was challenged was too broad. And they said that there was no such thing as a public trust doctrine in Canadian law. But however, on appeal, Justice Rennie of the Federal Court of Appeal said that the claim should be the Section 7 claim should be allowed to proceed if we amended the claim. And it was clear at the hearing of the appeal that we had done the first part of our job. We had made the judge want to find for us. But we did it by what I said before about bending the rules a little bit when you need to do that. So we knew we were going to face a motion to strike the claim, and that would have proceeded on the basis of the pleadings themselves with no more evidence. So you're not supposed to plead evidence in a Canadian originating application or statement of claim like we had here. You're just supposed to plead your material facts. But we filled our statement of claim full of facts about our individual plaintiffs because we needed the court to pay attention to what was happening to them. And at the appeal hearing, you could tell that Justice Rennie was moved by those facts because he asked Canada's counsel about it. He said, what about this thing I read in these affidavits about, the harms that are happening to these children? We thought, well, it did belong in an affidavit, but we didn't have any affidavits because it was a motion to strike. It was all in our statement of claim. He chastised us for putting evidence in our statement of claim, but he let our claim proceed. So you got to be careful. You don't always want to do that, but sometimes you have to do that. So La Rosa's, I see that I've taken up an awful lot of time here, but I'll just try and summarize what else I want to say about the climate change litigation. There is climate change litigation taking place throughout Canada and throughout the world. Here in Canada, the Mathur case, which involved a group of youth challenging an Ontario law which lessened the obligation on the provincial government to restrict GHG emissions within Ontario. That was challenged as a breach of Section 7 and 15. They survived a motion to strike. They lost at trial because the judge said this is actually a positive rights claim, not a negative rights claim, and you haven't pled it and proven it as a positive rights claim. The Ontario Court of Appeal said, no, it's not a positive rights claim, it's a negative rights claim. Back to the trial court to figure out if they've succeeded. Ontario has now sought leave to appeal to the Supreme Court of Canada on that case, and the plaintiffs in that case have cross-appealed, looking for the Supreme Court of Canada to give them their final remedy, which is a declaration of the breach of the Charter. So we are going to be hearing from the Supreme Court of Canada, if they decide to provide leave, on this question of whether there are obligations that rest on governments to take steps to limit GHG emissions. So is there a positive obligation on government to lower GHG emissions in order to protect charter rights of individuals in Canada? And they'll also ask them to decide, even if there's no charter obligation, if we decide to do it voluntarily, then is there some minimum standard that we have to meet? We'll be looking forward to that if the Supreme Court of Canada decides to take that up. It's a very important question. I think that this is the most likely context in which the court would recognize positive rights under Section 7. You know that the courts have been very reluctant to do that, but they haven't slammed the door on it yet. And a long time ago in another context, Justice Rennie of the federal court said maybe this is one of the places where you could have one of the contexts in which you could have a positive right under Section 7. So you can imagine we were quite excited when he was the chair of our panel on the appeal. And indeed, on the appeal, he said the fact that it's a positive right doesn't mean that it's can't proceed. But that positive negative rights distinction is a tricky one, and I am concerned about the Supreme Court of Canada hearing it when there's no one there, no party who's actually arguing for the positive right. So I guess the bottom line for me, for you, on climate change litigation is that climate change is the existential threat of our time. It's inconceivable that the courts don't have something to say about it. But it's very challenging to them to feel like they have a legitimate role because it seems very political and there is an enormous amount of balancing of competing interests. It's a very polycentric problem. So the trick when it comes to climate change litigation is framing a role for the court that is effective at modifying government action, but still they feel like they're within their lane. And there are cases all over the world, from Denmark, from the UK, from Colombia, from Ireland, from New Zealand, from everywhere you can think of, and from international bodies such as the International Court of Justice who are considering these things. And your task, law students and new lawyers, is to go through that litigation, those results, and find the ones that can help modify the way the Supreme Court of Canada or Canadian courts think about their role in this context. It's very tricky to use foreign law because, many cases they're based on a constitutional right to a clean environment or something like that we don't have. So you have to think really hard. This is where I'm talking about a deep understanding of the law. You have to think about where our constitutional rights are grounded and in what ways those foreign rulings can be tied to those constitutional foundations, the thing that underlie the text, even if they're not actually in the text of the Constitution. It's going to be hard, it's tricky, but it's a lot of good work for all of you. Off you go. I didn't leave as much time as I was meant to for questions, but we do have 10 minutes if anyone has any questions. Yes.
Well, good afternoon. I really enjoyed your lecture, and what I wanted to ask you, well, first of all, a comment. I think, I've heard lectures on advocacy before, and what you've addressed as much as style of advocacy is substance. The hard work, the preparation, the detail, the incredible detail that you may want to know about a particular case so that you can effectively advocate by knowing what you're talking about. And I think, for me, that's very welcome. What I want to ask you about was the aspect of courage. And it seems to me that when you're representing the homeless people in Victoria who face public criticism, I think, or Marie Heinen representing Jean Comeshi, and people are criticizing her for a variety of ways. And I think the aspect of courage is involved there in advocacy and the kind of work you're doing, and I'd just like you to comment on that. Thank you.
Thank you for that question. It was funny because the Adams case was in 2007 or something, and the Adamson case was about 10 years later. And when we did the Adams case, the first case, you're right. I mean, the newspapers were full of people kind of appalled that they were the homeless people were in the courtroom. The courthouse was a little appalled that there were so many homeless people in the courtroom. And nobody quite knew what to do with us. And we were very lucky to have a very thoughtful judge, Justice Ross, who had a background in sociology and was willing to listen to everything that we said and made a good decision, and was then subject to massive criticism throughout the country because of her decision. But by the time that case went to the Court of Appeal and the Court of Appeal upheld that decision, the newspapers were different. They were like, stop appealing this and just fix the problem, right? Enough litigation. They're not going away, because that was our point, is homeless people have to exist somewhere. So, and they have to be able to shelter themselves. So you can fix this problem in a variety of ways, but you can't just pretend like it doesn't exist. So it really changed even in those 3 short years. By the time we got back for Adamson, it was a completely different circumstance. The tent city took place in the courthouse lawn, but the court staff were welcoming to the homeless people. Chief Justice Hinkson, when he had all the homeless people in the courtroom, said, Ms. Boies Parker is representing some of you, but you haven't all signed the retainer agreement. So does anybody else have anything they want to say? And one by one, people stood up and spoke to the court. And again, these were people who have had very, very bad interactions with the justice system. They stood up, and the Chief Justice of British Columbia listened to them and said, thank you very much, sir. And they sat down, and it made a big difference to them, right? So I think you're right. You will face, and people, sent us hate mail and did different things because they thought this was horrible that we were representing homeless people. And in fact, you heard that the Bar Association gave us an award, but one of the executives said that when she told her friend that they were giving, she said something about, Catherine Boies Parker, the one who's doing that homeless case, and they said, oh, are you going to sanction her for what she's doing? And she's like, actually, we're giving her an award. But you're right, you have to sometimes go against public opinion when you're doing it. But public opinion will usually come around.
We appear to be entering the sort of post-facts era, or at least an era of sort of alternative facts at government levels. How's that going to change your approach? I mean, you've talked a lot about the amount of evidence and the quality of the evidence that you provide, but if governments don't give two hoots about facts and evidence, what does that do for the goals that you're trying to achieve? And I'm thinking, you know, notwithstanding clauses out the yin-yang, et cetera, et cetera. So I'm just curious about how that might change your approach.
Yeah, I mean, I hope the courts will be one of the last institutions to start ignoring the facts. But I think that we've seen in the United States that we have a Supreme Court that's kind of untethered from the law, so why wouldn't they become untethered from the facts as well? So I think that's a very good point. But to some extent, it is your last bastion of a place where there are rules. And if you put evidence that meets the rules in front of the court has a really hard time not accepting it. And sometimes because the court is acting based on those rules, it can make rulings that will allow the government to do things that otherwise it might not want to do. So if the court tells the government, you have to do this because you have a constitutional obligation to do it, then when the government goes to do it and everyone starts to scream at them, they say, I'm sorry, my hands are tied, the courts made me do it. You're right, the notwithstanding clause is a big problem there. But in one of the climate cases in the United States, the Juliana case, one of the judges said to the government lawyers, don't you need us? Don't you need us to tell you that this is your constitutional obligation because you're having such a hard time getting the political will to do it? And taking things out of the political sphere by putting them into an evidence-based process with defined rules can help in that regard.
On behalf of the students and faculty here at USask, thank you for sharing your experiences and your tools for effective advocacy with us. Your words are impactful and informative, and they inspire us to do good work as we advocate for others. Great. It's been an honor and a pleasure having you here.
Oh, thank you so much.
Before you go, we also have a certificate here
Lovely.
to commemorate this event.
Thank you.
And that concludes our event for today. Thank you.